Hello, everyone, and welcome to the Data Breaches and Cybersecurity, a Deeper Dive webinar. This program is brought to you by the ABA Young Lawyers Division Litigation Committee and International Law Committee. My name is Rich Rivera. I am the co-chair of the Litigation Committee, and I will be serving as your moderator today. The purpose of today's webinar is to provide a deeper dive into data breaches and cybersecurity, a topic which was covered at the fall conference in Detroit held last October. I hope everyone here was able to join us if they wanted to. It was quite a treat. That being said, the purpose of today's broadcast is to provide an opportunity to address audience questions and to go a little more in-depth into different areas of data breach litigation and cybersecurity. In the handout pane on the webinar panel, the PDF is available, which covers on a broad spectrum the topics that we're going to cover today, and we'll give you more of the overview of it and the kind of beginner's aspect to it. So please feel free to download that and review it at your leisure. In Detroit, we were unable to get the audience questions, so today we are going to be entirely question-based. The panelists will be posing questions between each other, and we will also be taking audience questions throughout the entire broadcast. So please place those questions into the question pane, and we will get the esteemed panelists to address them. Speaking of our panelists, today we have four great panelists. First is Claudia Rast. She's a shareholder based in Butzel Long's Ann Arbor office. She blends her expertise in law, business, and science in assisting companies in their strategic use of technology, counseling companies in the areas of privacy, cybersecurity, data theft, intellectual property licensing and registration, and the forensic preservation and analysis of electronically stored information. With the rise of cyber events in recent years, her background in forensics, IT environments, and security has become invaluable in working with clients to both defend against and respond to pervasive cyber attacks. Similarly, Ms. Rast is frequently called upon to negotiate contracts covering the innovative technologies associated with autonomous and connected vehicles to address security, privacy, IP ownership, and new and potential regulations. Next, we have Brigadier General Charlie Shug. Mr. General Shug is a retired Brigadier General from the United States Air Force and is a partner and the Chief Operating Officer of the Silent Group, Incorporated. In that capacity, he provides strategic guidance and insight for an elite team of cybersecurity and digital data forensic professionals providing security strategy and incident response to Fortune 500 companies, nonprofit organizations, and government entities. In his last Air Force position, he was responsible for providing trained and ready cyber forces to plan and conduct worldwide cyberspace operations. General Shug was a key architect and strategic planner of the U.S. Air Force's Cyberspace Operations Program and crafted concepts of operations for multiple worldwide organizations to include U.S. Cybercom. In addition, he was the commander of the DoD's Unmanned Aircraft Systems Center of Excellence charged with creating unified UAS concepts of operation. General Shug has been a featured speaker at numerous UAS and cyberspace events. Next, we have Todd Taylor, who serves as a member and co-leader of Moore and Van Allen's Commercial and Technology Transactions Practice Group, as well as its Privacy and Data Security Group. Mr. Taylor focuses his practice on outsourcing, licensing, data privacy and security, technology, and supply chain matters. Before joining Moore and Van Allen, Todd served as an in-house attorney at Bank of America, where he worked extensively on various technology licensing, supply chain, cross-border, and third-party servicing arrangements. Mr. Taylor has been engaged to speak for several programs on the topic of data breaches and cybersecurity, including the most recent presentations, Effective Data Security Management, Keeping Your Data Protected in the Cloud. Todd has also published several articles regarding the issues surrounding emergency threats and recent developments in corporate cybersecurity. And last but certainly not least, Alexander Major. Mr. Major is a partner and co-leader of McCarter and English's Government Contracts and Export Controls Practice Group. Mr. Major focuses his practice on federal procurement, cybersecurity, liability, risk management, and litigation. Mr. Major is a prolific author and thought leader in the area of cybersecurity. His professional experience involves a wide variety of litigation and counseling matters dealing with procurement laws and federal regulations and standards. His diverse experience includes complex litigation in federal court under the qui tam provisions of the False Claims Act and bid protest actions. He counsels companies of all sizes on issues relating to compliance with government regulations, including, among other things, cybersecurity requirements, multiple award schedule compliance, Section 508 issues, country of origin requirements under the Buy American and Trade Agreements Act, cost accounting, and small business requirements. He also regularly conducts internal investigations to assist companies ensure that they are in full compliance with the law. He is an editor and contributing author to the Cloud Computing Legal Desk book published by Thomson Reuters, an annual publication addressing cloud computing issues and solutions for commercial and government end users and suppliers. Mr. Major is also a retired U.S. Air Force and served as an intelligence officer who most recently served as the Academy Admissions Liaison Officer for the United States Air Force Academy for the state of Maryland in the Air Force Reserves. So now, as I've mentioned, we will be taking audience questions throughout the entire program. As there are none in here, I will start it off with a question that I'd like to have answered for my own benefit. And I'd like to ask the panelists, what trends have they all seen since the last time that we met in October?
More bad stuff, Rich.
Well, that's not good.
This is Claudia. The hackers out there are continuing. It's not a pace that's slowing down. They are increasingly more sophisticated. I think everybody can chime in with stories about the better English, the less grammatical error of the phishing campaigns, and the harder it is to get our employees and colleagues and clients and customers from clicking on those errant emails.
And Claudia, this is Charlie. I've seen a lot of ransomware starting to become more and more prolific out there. And estimates now, this quarter, we've already seen close to $1 billion worth of money change hands, and it's expected to continue to grow into the billions as the year goes on. And because it's that time of the year again in April, we've seen a lot of targeted phishing or spear phishing that's going on with people impersonating a senior executive in the organization and writing to their finance or their accounting department requesting W-2s for their organization, and it had to be done in a rapid manner because they had some issue. And later find out that the CEO never did request the W-2s, and they're now out in the wild. And the criminals will take that information and quickly start filing tax forms, fraudulent tax forms, to get a refund that will not be coming to the individual. And usually the individual only finds out when they go to file their tax forms, and then IRS tells them they've already filed and already been given a refund.
Right. Yes, I've seen that too, Charlie.
Yeah, this is Todd Taylor. You know, in the area I practice in, I do a lot of work with financial services institutions. There's a lot going on in the privacy and data security space with that right now. The FTC, I believe it was last fall, recently announced that they're looking at potentially updating their version of the safeguards rule under the Graham-Leach-Bliley data security requirements. And just for background, Many of you may think, well, the FTC really doesn't have anything to do with financial institutions. GLBA actually gives the FTC regulatory authority over essentially non-financial institutions that are substantially engaged in financial services activities. So there's the possibility the FTC may bring their data safeguards rule into line with what you see from more traditional banks, like the interagency guidelines that the OCC has promulgated years and years ago. I think something else we're seeing is the CFPB is continuing to kind of send mixed signals out on data privacy and data security. They, back in, I believe it was November, may have been December, they announced a RFI seeking information about whether they should do rulemaking in the data aggregation space. And for those of you who may not know what that is, there are third-party companies like Intuit with Mint.com, and there are other services out there like that, where any individual consumer can input their username and password, and that will allow Intuit, in my example, to go to a bank site and actually directly collect the bank data. A number of financial institutions, as well as some of the traditional regulators like the OCC and the Fed, have expressed behind the scenes and not so behind the scenes some concerns about data security associated with that data aggregation service model. However, the CFPB has actually sent some signals through their RFI process that they may rule-make to require financial institutions to make sure that data is electronically available, even through these third-party services. So again, I think in the financial services space, we're seeing a lot of back and forth as the regulators sort of stake out different paths. I'll also mention New York cybersecurity regulations the proposed cybersecurity regulations for financial institutions have been updated, and I believe those are going to take place or take effect in March, unless there's been some delay that I'm not yet aware of. But so I think that's going to be a continuing trend as we see in the financial services space, ever ongoing concentration on data privacy and data security.
This is Alex, and I think one of the things that I'm seeing, and this is maybe the good news, not only are we seeing the evolution of the threat, and specifically in things like malware and how those technologies are being used, or how the Internet of Things is being used to augment cyber attacks. I think the good news here is that we're seeing a lot of technology and a lot of birth of technology that is focused on preventing, discovering, or mitigating the attack. RSA just recently ended in San Francisco, and I think that was a huge portion of what RSA was talking about with the cyber kill chain. And the ability that companies have now, or at least the tools and technologies that are out there to assist companies. As we'll discuss later, I don't know if the companies are necessarily prepared to use those types of technologies, but they are out there, and a lot more prolific, and a lot more spending is moving in that direction. So with the threat being so persistent and so omnipresent, and a lot of companies recognizing that, you're starting to see a lot of very savvy, a lot of very smart technology companies really try to fill the void and try to be a lot more specific to attack, not just attack problems, not like a virus model, but rather a broader model for discovering and mitigating attacks. So I think that's the good news, is that there's plenty of help out there. Just have to be wise enough to figure out which one is actually helpful and which one is actually helpful for the particular company looking to buy it.
Alex,
This is Charlie, I'm sorry. Can Rich, could you put up slide 55, please? It's sort of a lead into Alex talking about the technology and everything being out there. Just some statistics that were brought to you by the ABA, and
that goes to my question to you, Charlie, and Alex and Todd as well. I find myself with clients who will call, and as lawyers, we know what the law is. Those of us in the cyberspace understand some of the implications of proper notice to both enforcement, to victims of compromised records, that kind of thing. But I'd like to hear your responses to those who say, well, if you make me incorporate those kinds of protections, if I have to do encryption on all my data. If I have to update to do this, then the custom software that I had developed 5 years ago for my operation will not work. I can't do it. How do you talk to your clients when they present with those kinds of difficulties? They can't incorporate the kind of technology, or they can't afford it.
Well, this is Todd. Maybe I'll start with that. I mean, it's actually, in the real world, I think that's a difficult question to deal with. I mean, as you know, from a legal standpoint, if you encrypt the data, that in many cases, if not almost all cases, exempts you from data breach notification requirements if in fact the data was truly encrypted and could not be read or obtained. Many states, most states, will indicate that's essentially not a data breach. So there is a legal benefit to that. However, you've got the business cost of, if I encrypt everything, does it take me longer to get access to the data? Does it make it harder for me to do business? In your example, will my technology actually still work? From a data security standpoint, a lot of the regulations that I deal with are sort of based on a reasonableness test. Now, that doesn't mean you still don't need to encrypt certain data. For instance, Gramm-Leach-Bliley does not formally require encryption. It requires you to analyze whether encryption is necessary, at least under the interagency guidelines. And so, what I would tell a client in that case is, look, let's look at what kind of data and what kind of sensitivity that data has for the kind of technology you're using, and then let's do a cost-benefit analysis. In some cases, the answer should be you're going to need to encrypt given the sensitivity of it, or at least you're going to need to find other ways to protect the data. In other cases, it may be less sensitive data, and you make a business decision that I'm not going to encrypt. But I think you have to go through that kind of analysis, and sometimes the answer is going to be a little more favorable or flexible from the business standpoint, and then sometimes, unfortunately, it's not.
Yeah, and I think it definitely is, as just indicated, I think it's definitely that's something that is segment related. So every segment's going to have a different requirement associated with it, and depending on what type of data the company's looking at protecting and why they're looking to protect it plays a big role in that. So a lot of my clients are in the government contract sphere and literally under the gun this year to have particular controls and requirements in place. Excuse me, and it's showing up in the phone call that I'm getting about how do we do this and what do we do and why do we do it. One of the things that is nice, I think that especially with the regulators, PCI is a little different, I believe, and PHI stuff is a little bit different. But for most of the regulators, I think what they're looking at is they are providing flexibility through the regulations and the requirements, which gives companies, again going back to what was just discussed, the reasonableness element of making sure that at the very least they're addressing a particular control or a particular requirement as reflected in the NIST standard for government contractors. Excuse me, the NIST special publications, but they're not demanding and directing a particular control be a particular level, or saying that you must use this or you must use this. So I think, as with all cybersecurity controls, that regardless of industry, I think it's really going to depend on the type of data that they have, the type of data that they need to protect, the type of data that they want to protect, and the type of data that they don't have to protect. And I think as long as the company has the ability to understand how those data are separated, then they're a little bit more better able. There's no need to employ all the gadgets and the gizmos to protect data that you don't necessarily care about. It's better to focus that effort on system critical data or company critical data, and then move off from there. Of course, that requires a little bit of quite a bit of knowledge of data governance and what your company has and where it has it. But I think that for companies that are unwilling to make that commitment, or unwilling to at least have someone come in and kick the tires to see what they're doing and how they're doing it, I think they're posed for some sort of malady, whether it's from a hacker or honestly probably a regulator as well.
And Alex, this is Charlie. For Claudia, I would what we tell our clients is they almost need to take a step back from all this and look at their risk tolerance. and look at the not only the cost benefit to it, but also the impact on their organization. We like to say that compliance and regulation, mean the regulatory requirements, does not necessarily equal security. So the companies should look at the impact of, are they going to, if they have a breach, where are they going to lose clients? Are they going to lose time? How long could they be inoperable? How much loss to their business revenue will there be? Take all those things into account, plus their reputation, their brand, all those types of things into the equation. Does everything need to be protected at the same level? You know, not at all. But if a company looks at where their biggest impact could be, that could affect the survival of their company, they either need to have something there that's state of the art, or what regulatory agencies would look for, or something, or they need to have some kind of compensation control that makes sure that there's some other procedure in the process that gives them some type of security.
Right, and you know, and the risk tolerance is an important point, Charlie, and I will often raise that with clients and say, look, do you have insurance for fire protection? And what is the likelihood of your building going down in flames? And what is the likelihood of any kind of cyber intrusion? And so that tends to make clients sit up a little straighter and understand the kind of risk analysis that we're going through and trying to protect them.
Sure. If you think if you look at, there's probably 100% probability that a company will have a breach sometime within the next 2 years, and then you look at what's the probability of a business having a fire in the next 2 years.
I think Charlie brings up, or General Chuck brings up a very good point too, and it's one that I foot stomp all the time, and it's almost, I don't know, patronizing or pedantic or some P word, but it really comes down to a balance too for a lot of companies. Everybody recognizes that they have to be compliant, but very few companies realize they have to be secure. And I think there is a balance and a natural tension between those two. And I think that a lot of savvy companies understand it, and a lot of unsavvy companies don't get it, because the two are not the same thing. I think a lot of companies, when they look at compliance, they literally look at check the box, because, you know, how much do we need to do to get over the quote-unquote line, whatever the line is, and because they're looking at what the good guys want, right? They're looking at what the regulators want. If you're worried about what the bad guys want, then you need to focus on security. So, you know, yes, by focusing on compliance, you're taking essentially maybe half of your possible risks away, or the people that could risk or pose a risk to your company and your company's data. But by focusing on security, you get a little closer to a fuller solution. The hard part with that, and I think this is where my heart goes out to any ISO, is that you're basically telling your company, yeah, we need to spend all this money and do all this stuff so we can be secure. The next question, of course, is, and will we be secure? And the answer to that is no, but we'll be closer than where we are now. But without any guarantees, and with the cost, and recognizing that cybersecurity is not necessarily it's a cost center and a cost suck. That's where I think a lot of companies sort of kind of fall down when they look at simply compliance and not security.
Yeah, this is Todd, and I'll follow on that point, because I think there were a couple of good points made in the last exchange. I mean, one, you know, you're right. We see this over and over again with clients who we work with. There's never really such a thing as 100% safety or 100% security. But from a legal liability standpoint, where you see the enforcement actions come down from the regulators, it really is, did you in fact do basic things? Did you take reasonable steps? For instance, if you look at the Wyndham Hotel case, if you look at the Dwala case brought by the CFPB, and there are others out there like that, it was really a failure of those institutions. Dwala was a payment processor, Wyndham Hotels, obviously a hotel company, where even after they were aware of their shortcomings, they really didn't do anything to address the shortcomings. They didn't take basic measures to protect the data. And that resulted in enforcement actions and fines and penalties, not to mention the reputational damage that they suffered as a result. So that could have been avoided even if the breach, certainly in Wyndham's case, a lot of their liability flowed not from the initial breach, but for failing to do anything following the initial breach. And so you take these measures not so much because it's going to be 100% prophylactic and prevent all incidents of unauthorized data intrusion, but you do it because, A, it will reduce the risk, and reduction of the risk is a frequent way to at least reduce and eliminate your legal liability both to regulators and potentially to third-party plaintiffs to the extent that they can get past some standing and other hurdles. The other thing I'll mention, we mentioned the fire analogy. You know, like fire, you insure against that. I would encourage you, when you're talking to your clients, to also think about data breach insurance to deal with some of the risks that are starting to emerge. In my experience, the coverage that is being offered by insurance companies is getting better and better. There are more options out there. There are different ways to sort of slice and dice the coverage you need. You can get coverage for PCI, payment card industry data security standard issues, regulatory issues, third-party claims, the cost of covering notification or setting up PR lines. And again, there's a cost to this insurance like anything, but I think your clients may be well served to at least go through that cost-benefit analysis to determine, based on the kind of business they're in and the kinds of places their data can be accessed or used, would they benefit by reducing some of their risk by having cyber breach or data breach insurance in place. I will caution, don't think your standard insurance policy is going to cover those things. Typically, you will need to price it out separately with a separate addendum, a separate rider, to make sure that you're getting the cyber and data breach insurance coverage. But again, it may be one way to also look at how to address your risk from a financial standpoint.
And Todd, if I can throw something on those, Charlie, I think the smart lawyers in this field, like you all are, could serve your clients very well, because some of the cyber insurance, until you read the fine print, we go in numerous times under insurance company and look for the cause of the breach and determine what left the company and what didn't leave the company. And then when that is all done, the client is very surprised that we're not there to also fix the problem on their insurance policy. And they're sort of caught at a loss at that point, and not having understood they just thought the cyber security or their cyber insurance would cover everything, and it's very specific.
No, that's absolutely right, Charlie, and then it's sort of the pro and con of those policies. You can basically slice it up to get all kinds of different coverage, but just because you have cyber and data breach insurance doesn't mean it will cover everything. For instance, it may not cover some of the remediation costs you were referencing, Charlie. It may not cover a PCI breach if you've not bought that coverage into your policy. It may impose certain limitations on your data breach notification costs. But again, if you look closely at the policies, you work with your underwriter or your agent, you can usually find a way to get the kind of coverage that fits for you. And I've used it with several clients, and they've, in fact, one recent incident, we were able to get our legal expenses pretty much covered without an issue. So again, it's something to look at. It's not a cure-all, and there's a cost to it, and you have to sort of balance the coverage you're getting versus the risk you have.
Yeah, and just been involved in a matter that involved a $2.5 million claim of insurance that will be covered, and which is a pretty substantial amount, which also included legal fees. And the hitch there, as some of you probably know, is that you have to be on the list of the insurance company as sort of the previously vetted or prior vetted counsel to do these kinds of things. But I want to go back to something that I think it was Alex talking about enforcement in Wyndham and then the FTC, which raised two things in my mind. One, the concept of marketing and how marketing departments can really pose huge problems, particularly when it comes with regard to security and privacy and law firms. And I mention that because we've attached the materials, the complaint, the class action that was filed against the law firm Johnson & Bell last April, which was publicly unsealed in December of this year. And there's some important lessons there for lawyers and particularly marketing departments, perhaps, of law firms who are trying to grab the opportunity that cybersecurity can bring to the practice of law, as you know, those of us on this panel are very busy doing that kind of work. But also, when you profess to have certain credentials in the area of cybersecurity and protection and client confidences, and then you start tapping away at what the actual infrastructure, IT infrastructure is for that law firm, as was alleged in this complaint against Johnson & Bell, it gets to be pretty scary. This class action alleged breach of contract in terms of confidentiality, negligence, citing the ethical rules of professional responsibility, citing 1.6, which is client confidences, but also I would point out in the Model Rule 1.1, which requires a certain technological proficiency, understanding technology. You know, I'm looking at the some of the patches that were not complete. There's a reference to, and although this gets really into the weeds of cybersecurity issues, the JBoss application server on page 7, Charlie will appreciate that too, I'm sure, with ransomware things. But Rich, you go to page 7 of that complaint, yeah, and on paragraph 20, this reference to JBoss applications. It was a JBoss server that was the source of the ransomware event that I spent a good several months dealing with on a facility. There's tremendous vulnerabilities with those. And again, as lawyers, we say, well, that's not what I went to law school necessarily, but you have to have technological competence when your clients ask you the questions. And that's the hard thing. So I'm curious for those listening in, our attendees out there, if you've had those kinds of conversations with clients, do you attempt to answer them yourself? Do you seek others that have the technological competence? Do you have that in your colleagues at your law firm? Where do you go? I'm curious. I think all of us on the panel would be, because we find that there are some firms out there with very active marketing departments and very thin groups of folks that may not understand the technology as much as they should.
And so,
yeah, I'd agree with that. I think that's one of the issues that a lot of people or a lot of companies run into in recognizing that. I mean, this is a, you know, for lack of a better phrase, this, you know, when you're talking cybersecurity, you are talking about quite a bit of prevention and very little dollar value coming in for it, / none. So I think that a lot of companies view cybersecurity services, cybersecurity vendors, cybersecurity technology as a like a boat, right? It's a hole in the water you throw money into. So I think it's vitally important that attorneys working with companies, or even attorneys working with themselves, recognize the importance of having someone at their side, be it a Tonto or a Robin, that understands technology, and the attorneys need to be conversant not only with what they understand about technology, and recognizing not only what they do understand, but also being very conversant in what they don't understand, and recognizing where those lines are, because I've had discussions with attorneys in cybersecurity. I've been doing this for a couple of years now, 4 years, and some attorneys really do believe they can do it all. I don't think they can. I think that there are technologists out there that are much better poised to assist, but not necessarily see the regulatory aspect or the implications or the full scope of risk that companies face.
And this is Charlie. For full disclosure reasons here, we are with Moore Van Allen, Todd and I, we, I would say, collaborate on many things. And if they have a question with their client or something, just pair up with a company, like ours, and we talk through the issue and give all the options and just sort of make sure that they're give them. I guess I would say, Todd, just sort of make sure, confirm the things you're thinking, or add a few things to your tool chest, and then then go off with the client, and whether Todd calls me back or not relating to that it's just our relationship, doesn't matter, but he's got a trusted partner there to help out with those technological issues and possibilities.
No, and I agree with that, Charlie. And what I find, and I agree with what Alex was just saying. I mean, in my personal case, I know enough about the technology issues, frankly, to be dangerous. I know at a high level what the issues are, but I'm not working on a day-to-day basis with the actual technology, the actual, what the current daily threats are that are out there. And that's why I think, there are firms like Silent, the group, there are other firms out there like that where, I find it helps to lean on those people and really call them right away to make sure the way you're thinking about the issue is correct. Because oftentimes, look, we know as lawyers, we know the laws, we know the regulation. We should know how the laws and the regs apply to the facts and apply to the technology and the issues. But to actually understand what's going on with the technology or the security threats, my view is, go to the people who are doing it on a daily basis and understand that. And it really does have to be a partnership where you understand that. And, if you're an in-house lawyer at a very big company, my prior employer had people, who worked in internal information security, who were former Secret Service, military, FBI, you name it, and they were top-notch people. And so some of you as in-house lawyers may have those resources internally, and I think it's just incumbent on you as a lawyer to make sure you're regularly talking to them, and because they're going to miss the legal issues some cases, and you may miss the technology issues. So it's just important to have that back and forth conversation to make sure that collectively you guys are seeing 2020.
I think Claudia raises a very good point that the marketing arm of firms, as well as marketing and sales arms of private companies, tend to oversell what they don't necessarily understand is going on the other aspects and the other sides of the companies. I know, for example, I'm a litigator. I know my limitations, and when I have a problem come up in a case, I reach out to an expert witness instead of trying to handle it myself. So that's the way I think that attorneys should be addressing these issues, getting the experts involved, as Todd and Charlie mentioned. But I'm going to go ahead and pivot here and change the direction of the conversation a little bit. I'd like to ask the panelists, what impact do they see, if any, in cybersecurity and other regulation due to the changeover from the Obama to the Trump administration? For example, I know President Trump has now announced a requirement that for every new regulation, 2 previous regulations from that agency must be stricken from the books. So do we see that as affecting the ability to put in new regulations, or are the regulations currently robust enough to handle the change in technology and stuff?
Which is an interesting question, and there are 2 aspects of it with different kinds of directions. The first with regard to the regulation issue and budget cuts that may come from that. I've seen in the literature in the last couple of months, the focus will be on states doing enforcement, whereas in terms of not as much federal enforcement in this area of cybersecurity. And you have laws like the New York law that will be effective March 1, was delayed from its January 1 effective date to March 1 with what I think 180 days is a ramp-up period. So states jumping in and doing that. But on the other hand, in terms of what's going on in the cybersecurity policy discussion and addressing the sort of substantive concerns that we have as a government and as a nation, I've also seen folks saying that they have not yet seen any difference or a change in focus and concern about cybersecurity and protection.
This is Charlie. The President should be putting out an executive order here soon. Everyone's been anticipating for the last month. But some of the people that he charged, he had to change. But it looks like that the executive order will come out, and it's really going to be an inward look at the government itself, and looking at the country's cyber adversaries and getting an assessment using DHS and NSA, with telling a group for the Secretary of Commerce to prepare a report on how to incentivize the private sector, and then using the Secretary's Defense and Homeland Security to work with the Department of Education to get our cyber training up to date. It appeared that most of these things will have deadlines of 60 days, which I'm not sure they'll be able to make once the executive order does come out. But I think there's going to be a lot of inward looking on government agencies so they can talk the talk and walk the walk before I think any regulations will come out with private sector stuff.
I agree with that. I think you're right. I've seen the draft copy, and it didn't look didn't look that much different, candidly, from what the Obama administration had. But the big thing I think a lot of commercial companies, especially clients like mine, that need to be wary of is the government is never going to do this stuff on its own. They're going to require their contractors to basically do it for them, and they're going to hold contractors compliant to those standards. So I fully expect that on the commercial side, and this is always, I think, has always been the case, to the extent that there are going to be changes, that it will be focused on the government contractors first and foremost. The good news here is I think the government recognizes, like I spoke about earlier, that there's got to be some flexibility, because Lord knows we don't want the government dictating their requirements to any great degree, because that would be a frickin' mess. So they are going to leave it up to the companies, leave it up to industries, or sectors, and for the government contractors, probably just maybe tweak and refine the NIST Special Publication 800-171 like they did in December. So they're going to be fine-tuning the controls and the requirements, but I don't suspect, in light of how broad those special publications are and what they require, I don't expect there to be a huge change or a huge sea change in how government contractors are going to be required to meet the this administration's new vision. I also wonder, quite honestly, how much attention is going to be given, and this is a whole other topic, but how much attention is going to be given cybersecurity under General Mattis's vision of what he wants the Department of Defense to be, simply because recognizing where President Trump, as well as some of the things Mattis said, technology isn't going to be the focus. It looks more kinetic. So I'm very curious to see how that works out.
Yeah, this is Todd, and I don't know if I really have a lot to add to what the others say. I mean, I generally agree with Claudia that I'm seeing, and I suspect we'll continue to see increasing activity at the state level, in terms of not only, as Claudia mentioned, as I'd mentioned earlier, the New New York cybersecurity regulations that apply to financial institutions that are regulated by the Department of Financial Services in New York. But other states have, passed laws and regulations in the area of cybersecurity. I suspect more will do so. I suspect state attorney generals are going to pick up slack in instances where the Trump administration, or at least some of the governmental agencies, may be a little less involved on the enforcement level. I think it's kind of hard to predict at this point what's going to happen. I had mentioned earlier, I suspect we're going to see the FTC update their safeguards rule. If I had to bet, I would bet the FTC may step back a little from not enforcement per se, but it maybe not being quite as aggressive. They had they took a bit of a hit on the nose in the LabMD case recently, and with the changeover in some of the players in the FTC, it wouldn't shock me if there's at least less aggressive enforcement activity of the FTC, but that's just speculation. The CFPB has started to get involved, and they did last spring with the Dwala case in the data security regulation under their unfair and deceptive acts and abuses regulatory enforcement authority. It's up in the air what's going to happen to the CFPB right now. There was a D.C. Circuit case, a 3-judge panel of the D.C. Circuit last year basically said Cordray was the way his appointment power, or the way he is selected, is unconstitutional, and therefore the president could replace him at will. That decision has now been accepted by the full D.C. Circuit for a decision, so it's possible that decision may get overturned. If it is not, it wouldn't shock me if Trump replaced Cordray, and if you saw again maybe the CFPB not being as aggressive on cyber and data security enforcement in the areas that they have regulatory authority over, which is primarily consumer financial products and services. But again, that's speculation. There's so many things up in the air right now with the CFPB, it's just hard to gauge. But I do think states are going to stay active. The other thing I'll mention that sort of follows on Alex's comment, I think what you're going to continue to see is in the vendor management space. My space is more financial services. I do some work in the government side, but not as much as Alex. But I see a number of financial institutions be very aggressive about making sure their vendors are compliant with information security policies and procedures and rules that they as financial institutions have to live up to. So I suspect a lot of these things that we're talking about in information security are going to be enforced as much by contract, if not more so by contract, than they are by formal laws and regulations. Because, while many companies may be subject to HIPAA and GLBA or FISMA through government contracts, it's really where things get flowed down to the downstream parties, I think, where those laws really start to take effect, whether through business associates, whether through vendors of financial institutions or government agencies. And I do not see that trend of sort of contractually requiring information security going away. If anything, I think it's going to get even more stringent.
Yeah, Todd, and if we go back to Charlie's slide 55, again, and because we lawyers and we as law firms, from solo to large firm to in-house, we are obviously vendors and suppliers. We are getting those kinds of questionnaires. We are having to become compliant. And if we look at how uncompliant as an industry we are, and I'm sure we all know the colleagues who will get a questionnaire from a financial institution, and in order to do the deal, in order to make the business, in order to gain that client, they will just say, oh, sure, we got this covered. Right, Charlie?
And Claudia, a great point there is we've run into a few clients that went all the way with their business associates and had that written compliance, and then when rubber hit the road and there was a problem, those companies didn't have any financial backing to put up or shut up kind of deal, and ended up just going bankrupt versus ensuring they had cyber insurance or something behind that legal contract. And the paper was written on sort of was worth nothing.
Yeah, we're seeing that more and more on the government contract space. And I'll tell you what, some companies, especially small businesses or suppliers to larger primes, are not fighting back, and they don't realize that they're signing up to specific requirements that A, they don't need to, or B, that they just literally can't maintain. And that's going to not only run the risk of False Claims Act liability, which is very bad, but also breach of contract, which is equally as much of a pain in the butt. So you're absolutely right that nobody wants to take responsibility for it. So they will always kick the can down the road, or at least push it down, because we all know what rolls downhill first.
And yeah, I couldn't agree more with that. I see the same thing with vendors in the financial services space. There's simply a lot of small vendors simply do not have the capability to meet some of these requirements. And even if they did, to Charlie, to your point, the sort of asking for unlimited liability for some of these companies in your contract, it's an academic exercise, right? Fine, I'll sign up for unlimited liability, but they have either insufficient insurance or they simply don't have the financial means to sort of back that up. And so really, when you're contracting with these parties who may be vendors to your clients, or where you may be representing a company that's a vendor to another institution, if you're on the client side, the customer side, I think one question is this company even able to live up to their protections? It's wonderful to get these words in a contract, but if you haven't done due diligence on their financial ability and their actual practical ability to meet the concerns, then the question you really ought to ask yourself is, should this even be a company I'm contracting with, rather than let's get the best words in the contract. And if you're the vendor providing the services, or you're representing the vendor, I think you really should go through, as Alex suggested, is this requirement even applicable to what I'm doing for this vendor? Or this customer? Do I have card data, for instance? Why am I signing up for all these requirements that are really applicable for PCI DSS compliance, but if I'm not handling card data, it doesn't really matter? Or if I'm not handling sensitive customer, consumer, or personally identifiable data, do I really want to encrypt all the confidential information the client sends me? And let's have a meaningful conversation about that. I think a lot of times, lawyers write these wonderful information security provisions in the contract. They hand them off to the business people to go and use in their vendor situations, and it doesn't fit the actual service being rendered. So I think a little more thought ought to be put into that as lawyers when we're negotiating those contracts.
Well, Charlie raised an interesting point earlier, saying that virtually every company is going to be the target of a cyber threat or attack during the next 2 years. So that raises the question, what does a cyber threat resilient company look like?
They work out of a cave and they have no electricity.
This is Alex. I think it really is a company that remains flexible. But I think more than anything, it's a company that has a structure that is focused on recognizing the threat. And this goes back obviously to General Shug and I's background, but you need to be prepared. And companies, I don't think, are prepared, because companies are there to make money. Companies are there to generate income, and they're not necessarily in a position or set up to recognize that they're being attacked. They're set up to recognize market trends. They're set up to recognize stock trends and opportunities for growth, but they're not set up to recognize the threats posed to them by this technology. So I think that a cyber resilient company is a company that truly has a segment or a sector that is focused and listening to recognizing the threats that are out there. And that is not to say that those are companies that are buying into a lot of this threat intelligence and a lot of these technologies. It is those kind of companies that are ready to respond to those types of threat intelligence. So again, to use a military model, intelligence isn't worth anything if you can't act on it and you can't make decisions based upon it. But that decision is what intelligence is all about. And a lot of companies are signing up for threat intelligence, and that's great. So they know that stuff is out there and they know there are problems. But to be really cyber resilient, you need to be prepared to act on it. You need to be prepared to listen to it. You need to be prepared to change and morph. So I think a lot of companies aren't cyber resilient that think they are because they're not ready to respond when they get hit.
Well, and even more fundamentally is what do they do when it happens? Do they even have an incident response plan in place? And I would posit, and I don't know if Charlie, you have a statistic for that comes from legal tech. I don't know if I think there is some statistics on that, but for the most part, I would be willing to bet, and anybody in the audience, if you have an incident response plan that you know of, if all of a sudden you go into your office or you're out and you open your laptop and you see a virus of some kind affecting or impacting, do you have a plan in place to call someone in your firm or a colleague to get the proper things going and the proper response? And that's really, even the fundamental, who you're going to call is where many lawyers and many law firms are lacking there.
And this is, Charlie, just a simple question I'd ask for all the law firms. They could start with themselves, then they can get a feel for talking with their clients, is to ask yourself, how does sensitive information enter into my law firm? Do we create it within the law firm? And where does it go? If you can answer those questions, you could probably figure out which systems need to be protected for that risk tolerance. And then I think you'd probably find out a few, horror stories that we wouldn't tell out of school, but how USB drives get passed around, how many clients have had a malware on their USB drive when they hand you their litigation data, and then it gets transferred into your system. They unknowingly had it on their system, and then now they pass it to your system. How many times does sensitive data go on attorneys' laptops and then home computers and everywhere else? And then when they're done with it, don't realize that the cache is left on their computer after they're done with that document. And when it's all over with, what really happens to all that data in the law firm in order to get it off their system, or to destroy it, or to send it back, or to store it somewhere? So I'm not sure a lot of people do a very good job of accounting for where all their data is going at one time.
The interesting thing you mentioned about data, Charlie, and it's true in law firms, but it's also true with our clients. And I find an interesting entree in this discussion, and particularly among young lawyers, as opportunities to do additional work for clients, is this whole idea of document retention and destruction. If you don't need it, don't store it. It just becomes discoverable in the instance of litigation and in the instance of any kind of breach. Look at Mossack Fonseca with 40 years of client data. There was no reason in the world to be storing 40 years worth of client data on a server.
Exactly right.
Well, these are all great points and good things for firms and companies alike to consider in making themselves more resilient to ongoing cyber threats and data breach issues. With that, however, we have reached the end of our allotted time. I would like to thank our esteemed panelists for agreeing to come and speak and answer all of your questions and give this follow-up to our basic primer on cybersecurity and data breach litigation from the 2016 Young Lawyers Division Fall Conference. So I'd like to thank all of you for attending today's webinar. We hope that you will join us for future webinars. To learn more about the upcoming program in the Young Lawyers Division, visit www.ambar, that's ambar.org/younglawyers. And coming up this Friday, February 24th, we will be hosting, and that is the Young Lawyers Division Litigation Committee, will be hosting a teleconference at 12 noon in the Best Practices series on conducting and defending depositions. And we hope that you will be able to join us. So again, thank you to the audience and thank you to our panelists. And this will conclude our webinar on a deeper dive into cybersecurity and data breach.
Thanks, Rich.